These people are captured and held indefinitely without any charges being filed, and are held without being identified to the Red Cross or to their families. Many are clearly innocent, and several cases, including one in Canada and one in Germany, have demonstrably been shown subsequently to have been in error because of the similarity of names or because of misinformation provided to U.S. authorities. Such a policy is in clear violation of U.S. and international law, and has placed the United States in a position of a pariah state. The CIA has no law enforcement authority and cannot legally arrest or detain anyone. The program of extraordinary rendition authorized by the President is the substantial equivalent of policies of disappearing people. Practice is widely practiced and universally condemned in the military dictatorships of Latin America during the late 20th century. The administration has claimed that prior administrations have practiced extraordinary rendition, but while this is technically true, earlier renditions were used only to capture people with outstanding arrest warrants or convictions who were outside in order to deliver them to stand trial or serve their sentences in the United States. The President has refused to divulge how many people have been subject to extraordinary rendition since September 2001. It's possible some have died in captivity. As one U.S. official stated off the record regarding the program, some of those who were renditioned were later delivered to Guantanamo, while others were sent there directly. An example of this is the case of 6 Algerian Bosnians who immediately after being cleared by the Supreme Court of Bosnia-Herzegovina in January 2002 of allegedly plotting to attack the U.S. and U.K. embassies were captured, bound, and gagged by U.S. Special Forces and then renditioned to Guantanamo. In perhaps the most egregious proven case of rendition, Maher Arar, a Canadian citizen born in Syria, was picked up in September of 2002 while transiting through New York's JFK Airport on the way home to Canada. Immigration and FBI officials detained and interrogated him for nearly 2 weeks, illegally denying him his rights to access counsel, denying him the right to access the Canadian consulate and the courts. Executive branch officials asked him if he would volunteer to go to Syria, where he hadn't been for 15 years, and Maher refused. Well, Maher was put on a private jet operated by the CIA and sent to Jordan, where he was beaten for 8 hours, and then delivered to Syria, where he was beaten and interrogated for 18 hours a day for a couple of weeks. He was whipped on his back and hands with a 2-inch thick electric cable and was asked questions similar to those he had been asked in the United States. For over 10 months, Maher was held in an underground grave-like cell, 3 feet by 6 feet and 7 feet deep, which was damp and cold, and which the only light that came through a hole in the ceiling. After a year of this, Maher was released without any charges. He's now back in Canada with his family. Upon his release, the Syrian government announced he had no links to Al-Qaeda. The Canadian government have also said they found no links to Al-Qaeda. The Canadian government launched a commission of inquiry into the action of Canadian officials in relation to Maher Arar to investigate the role of Canadian officials. The Bush administration refused to cooperate with the inquiry. Hundreds of flights of CIA-chartered planes have been documented as having passed through European countries on extraordinary rendition missions like that involving Maher Arar, but the administration refuses to state how many people have been subjects of this illegal program. The same U.S. laws prohibiting aiding and abetting torture also prohibit sending someone to a country where there's a substantial likelihood they may be tortured. Article 3 of the CAT Treaty prohibits forced return where there is a substantial likelihood that an individual may be in danger of torture and has been implemented by federal statute. Article 7 of the ICCPR prohibits return to country of origin where the individuals may be at risk of either torture or cruel, inhuman, or degrading treatment. Under international human rights law, transferring a POW in any nation, strike that, transferring a POW to any nation where he or she is likely to be tortured or inhumanely treated violates Article 12 of the Third Geneva Convention, and transferring any citizen who is a protected person under the Fourth Geneva Convention is a grave breach and a criminal act. In situations of armed conflict, both international human rights law and humanitarian law apply. A person captured in a zone of military hostilities must have some status under international law. He is either a prisoner of war and as such covered by the Third Convention, or a civilian covered by the Fourth Convention. There is no intermediate status. Nobody in enemy hands can be outside the law. Although the state is obligated to repatriate prisoners of war as soon as hostilities cease, the ICRC's commentary on the 1949 conventions states that prisoners should not be repatriated where there are serious reasons for fearing that repatriating the individual would be contrary to general principles of established international law for the protection of human beings. Thus, all of the Guantanamo detainees, as well as the rendition captives, are protected by international human rights protections and humanitarian law. By all of his actions, as outlined above, the President has abused his power, broken the law, deceived the American people, and placed American military personnel, and indeed all Americans, especially those who travel or live abroad, at risk of similar treatment. Furthermore, in the eyes of the rest of the world, the President has made the U.S., once a model of respect for human rights and respect for the rule of law, into a state where international law is neither respected nor upheld. Now, in all these actions and decisions in violation of United States and international law, President George Bush has acted in a manner contrary to his trust as President and Commander-in-Chief, and subversive of constitutional government, to the prejudice and cause of law and justice, and to the manifest injury of the people of the United States. Wherefore, President George W. Bush, by such conduct, is guilty of an impeachable offense, warranting removal from office. Article 20, imprisoning children. In his conduct while President of the United States, George W. Bush, in violation of his constitutional oath to faithfully execute the office of President of the United States, and to the best of his ability preserve, protect, and defend the Constitution of the United States, and in violation of his constitutional duty under Article 2, Section 3 of the Constitution, to take care that the laws be faithfully executed, has both personally and acting through his agents and subordinates authorized or permitted the arrest and detention of at least 2,500 children under the age of 18 as enemy combatants in Iraq, Afghanistan, and at Guantanamo Bay Naval Station, in violation of the Fourth Geneva Convention relating to the treatment of protected persons and the optional protocol to the Geneva Convention on the rights of the child on the involvement of children in armed conflict, signed by the United States in 2002.